All right, so today we have an interesting story about Alex Jones, who skipped a deposition in the Sandy Hook defamation case. You might remember that Jones was sued back in 2018 for defamation by victims of the Sandy Hook Elementary School mass shooting in Newtown, Connecticut, that killed 26 people. Jones made claims that the shooting was completely fake and a giant hoax perpetuated by opponents of Second Amendment rights, the right to bear arms. The families of the victims sued Jones after suffering harassment and ridicule from Jones' false statements. During the litigation, Jones has regularly failed to cooperate in the judicial process. He was found in contempt of court in 2019 for failing to cooperate with discovery and fined $126,000. He was held in default after further failures to turn over documents and evidence as ordered by the court, in a show of flagrant bad faith and callous disregard for the responsibilities of discovery under the rules. Now, Jones is scheduled to sit for a deposition regarding his basis for making the false claims about Sandy Hook. On March 21st, Alex Jones' attorneys then sought to delay the taking of that deposition on the advice of Jones' doctor that he is not well and must stay home. The deposition was scheduled for March 23rd and 24th. The court held a hearing on March 22nd. During the hearing, it appeared that Jones was live streaming his daily video podcast from his studio and not staying home as the doctor ordered. The plaintiffs moved to have him arrested and forced to attend the deposition. The judge didn't have him arrested, but did order him to attend the deposition on March 24th, I think it was. I have 25th in my notes here. And Jones reportedly then did not attend the depo on March 24th. And today we're going to go over those documents. We're going to see the motion for the protective order. We're going to reenact the hearing that the judge held on March 22nd. We're going to see the second doctor's note because they never actually presented the first doctor's note to the public. Sort of understandably, you might not want to share your doctor's note. We're going to read the corrected record filing by Jones' attorney regarding where Jones was. There will be a few court orders. We will see the notice of Jones' failure to appear and read the plaintiff's second contempt request. We'll start with this March 21st motion for protective order regarding the deposition of Alex Jones. The defense says, the Jones attorneys say, at approximately 3:30 p.m. this afternoon, the undersigned, Jones' attorney, received a telephone call alerting him that Mr. Jones was under the care of a physician for medical conditions that require immediate and possibly emergency testing. I spoke with a person representing himself to be a physician. He told me he was a licensed physician, had the qualifications to render such an opinion about Mr. Jones' health, and that his opinion was that Mr. Jones should not sit for depositions this week. I asked for a second letter from the physician. My client has not asked me to disclose the nature of the medical conditions or the identity of the physician. It is my hope that upon receipt of the physician's letter, I can share it with the court on an ex parte basis, which means sharing it with the judge, but not with opposing counsel. You'll see more about that in the moment. Respectfully, defendants move this court for an order to postpone the deposition of Alex Jones for a reasonable period of time consistent with his medical condition. So then, the court did schedule a hearing regarding that motion. That hearing was held on March 22nd before Judge Barbara Bellis of the Judicial District of Waterbury in Connecticut. And joining us here in the virtual studio is Tactical Bry, your favorite judge reenactor. Tactical will be playing the court, who is Judge Bellis, and I will read all of the other parts. So Tactical, whenever you're ready, start with page 1, the court.
All right. Good afternoon, everyone. We are on the record in the Lafferty versus Jones matter. And if plaintiff's counsel can identify themselves for the record.
The several attorneys involved with the matter then introduce themselves: Attorney Matee or Matai, Attorney Atkinson, both for the plaintiffs. Then the court is unsure who's speaking for the Jones defendants, and that's going to be Attorney Smith.
Okay, so the ball is in your court, Attorney Smith, and I would be interested in hearing from you as to the other restricted activities besides the purported recommendation from the physician that your client not attend the depositions.
Yes, Your Honor. I am not aware of any other restricted activities other than to say that he is remaining home under the supervision of this physician as we understand it, pending the results of tests that have been arranged.
Okay. And do you have, and I'll hear whatever argument that you might have, but do you have any evidence that the court can hear?
Your Honor, we did receive a letter yesterday afternoon here at the office from the physician. Again, we've been authorized to share that with the court in an ex parte manner for an in-camera review. In-camera means the judge would review it in their chambers and not review it publicly on the record. And I can provide that to the court. However, the client thus far, as I understand it, has not authorized disclosure to the other side.
So you're looking to submit ex parte the letter from the physician?
Yes, Your Honor, for Your Honor to review in camera, similar to a motion for confidential records, disclosure, or something of that nature.
All right. And what else? Before I hear from plaintiff's counsel, is there anything else, Attorney Smith, that you wanted to mention?
Well, Your Honor, I guess I could respond seriatim, or point by point, to some of the claims made by the plaintiffs. First off, we do have a doctor's letter in hand, which I received yesterday afternoon. I myself have not spoken with a doctor, but as Attorney Pattis wrote in the motion, he has. And then we did thereafter receive that letter, which the doctor told us.
Attorney Smith, I'm sorry, I apologize.
Yes, Your Honor.
I'm just going to interrupt you for a second. I just want to sort of address first this in-camera submission, because the last thing
Yes, Your Honor.
that I read, sir, was that your client, had not authorized your firm to disclose the name of the physician or the medical diagnosis. So that's changed since your filing?
Your Honor, I believe that the filing was that it wasn't. We weren't authorized to disclose that to the opposing parties. However, we have authorization to disclose that to the court, and I think we asked for that to be done ex parte. I'm not sure when I saw the motion, which I did not draft, I'm not sure that we asked for, in particular, for an in-camera review, but as I conceptualize it, that's what's being requested.
So I'm going to read to you, Attorney Smith, because we all need to be accurate here.
Yes, Your Honor.
The amended motion for protective order that Attorney Pattis filed. I'm just going to read the last full paragraph. My client has not authorized me to disclose the nature of the medical conditions or the identity of the physician. It is my hope that upon receipt of the physician's letter, I can share it with the court on an ex parte basis. So the last filing, just to be accurate, because you need to be accurate with me.
Yes, Your Honor.
The last filing in this official record is that there was no physician's letter and there's no mention of any in-camera review, correct?
There was no physician's letter and there was no mention of in-camera review, correct. I did not hear that in the motion, Your Honor.
All right.
However, it said,
Listen.
Believe it said that after we received it, hope to get authorization to share it with the court ex parte. So that's what I'm representing. I guess that's a change since yesterday afternoon when that was filed. We do have the authorization to share that with the court ex parte for the court obviously would have to review that in order to make its determination.
So just so that you're clear, and we're all clear, right? The filing, your filing, at that point of your filing, your last filing in the official file, your client had not authorized you to disclose the medical condition or the name of the physician, putting aside a letter which had not yet been received. So are you correct?
Had not authorized us to disclose that at that point. Yes, Your Honor, that is correct.
Okay. So what has changed from the filing of your motion for protective order? You're now authorized to submit it in camera. And I haven't heard from plaintiff's counsel on that yet. And you've disclosed that to plaintiff's counsel, or is this news to them?
This is the first time that I'm having any discussions with plaintiff's counsel, Your Honor. So I don't know unless I know Attorney Mate and Attorney Pattis have had discussions that I'm sort of brought up to speed on. I don't know if they've had any discussions with regard to that. We have received a letter and we have been authorized to disclose that to the court.
Attorney Matai, are you speaking for the plaintiffs?
Yes, Your Honor.
Had you heard before now that there was a letter and that the defendants were looking to submit it in camera?
The only information I had relating to that, Your Honor, is what was in the amended motion for protective order that was filed yesterday. And that was, I had had a conversation with Attorney Pattis prior to that in which he relayed to me that if he received a letter, he would be looking to submit it ex parte. But I had no information regarding Mr. Jones' authorization prior to just hearing that from Attorney Smith.
All right. So, Attorney Smith, for the first time, you're now orally requesting an in-camera review ex parte of this letter, correct?
Yes, Your Honor.
Okay. And you are authorized to disclose even the name of the physician, or is that something that your client is not even willing to share?
Again, not with the opposition, Your Honor, but certainly that's all available. All that information is contained within that letter, which I'm authorized to disclose to the court.
Okay. And so this is not something that under seal can be filed, so that it would be confidential, not released to the public, but just to opposing counsel.
Your Honor, I don't have that authorization at this point, no.
Okay. And so can I ask you, Attorney Matai, if you're able to respond? I know this is the first time you're hearing this. What is your position on an in-camera review?
We oppose, Your Honor, any ex parte in-camera review of the letter that purports to justify Mr. Jones' excusal from his deposition. We think that the procedures that have been followed in this case to date protect sensitive information, including medical information, and those should be followed. That would be the filing under seal of any sort of personal protected medical information of Mr. Jones, so that the plaintiffs can then have a full and fair opportunity to oppose the requested postponement if the court is in fact going to rely on that letter. And we think that that should address any of Mr. Jones' privacy concerns.
All right. So, Attorney Smith, and I'm going to give you as much time as you want. I really don't mean to cut you off, but I'm going to see if I can deal with this without the necessity of an in-camera review, because I want to see how detailed this letter is. So it's from a medical physician who's currently licensed.
As I understand it, Your Honor, yes.
Okay. And are you able to say what state the physician is licensed in, or what states?
I am not, Your Honor. Again, we got this letter yesterday afternoon. It doesn't reflect that information. I haven't directly spoken with this physician. That was Attorney Pattis who did so. I'm covering this because he is in flight.
I understand. So from the letter, I cannot glean where the physician is licensed or if they're currently licensed. Is that correct or incorrect?
That is correct from the letter, Your Honor.
All right. So I just want to make sure when you say that it's correct. So if I were to look at this letter, I could not tell if the physician is currently licensed. True or false?
True.
Okay. And I could not tell where the physician practices. True or false?
True.
All right. Does it have an address for the physician?
No, Your Honor, it does not.
Just give me a moment. All right. So it doesn't address the state the physician is in, whether he's currently licensed, and where he's located, in a nutshell.
Correct, Your Honor.
Okay. Does it address how long? Does it address whether there is currently a patient-physician relationship between Mr. Jones and this physician?
Yes, it does, Your Honor.
And are you able to state I don't want you to get yourself in a pickle, but are you able to state whether the letter indicates that there is a current patient-physician relationship, or how long that relationship existed? Or is it 2 days or 25 years?
Your Honor, particular length of time isn't stated. However, it appears to be a current relationship.
And are you able to tell me what other restrictions besides the deposition, what other restrictions are in the letter?
Again, Your Honor, without getting too deeply into it, there are other restrictions there, including remaining home under doctor's supervision pending testing results.
All right. So can you tell me whether there are any physical restrictions? Don't work out, don't exercise, whether there are any driving restrictions, whether there are any work or work-related restrictions. Does this just address the restrictions for the deposition?
Well, Your Honor, I think there is a general restriction regarding remaining home pending these.
I understand, but
under his supervision, pending these test results. The only specific restriction that it addresses, there's nothing like do not drive, anything of that nature. The only specific thing that it addresses would be attending depositions this week.
All right. So I guess what I'm trying to figure out is whether, I don't know if Mr. Jones, for example, has a home gym, like maybe people do. Does it address, so I understand the recommendation is remain home. Is it remain home and don't physically exert yourself?
Your Honor, it doesn't specifically say remain home and don't physically exert yourself. Again, it's more general than that. It could certainly be viewed as encompassing that.
And does it address whether Mr. Jones, the recommendation is that he not engage in any work or work-related activities while home? So, for example, sometimes we're in this remote venue from home and yet we're working. So does the letter address whether he can work or not? And I say that because, as I'm sure you saw in the objection that was filed, there was an indication that Mr. Jones was live on the air for 4 or 5 hours yesterday, in addition to other broadcasts.
Your Honor, it does not address that.
Okay. And is there a date and time on that letter?
There is a date at the top. I do not have a time.
And the date is what date?
March 21st, 2022.
And who is the letter addressed to? Were you able to say that? Is it to whom it may concern? Is it to Attorney Pattis?
It is to whom it may concern, Your Honor.
All right. Just tell me how many sentences in the letter.
If you'll hold, I'll count them. 7 full sentences, Your Honor.
So, if, for example, Attorney Smith, the court wanted to determine whether the letter is genuine, how would the court do that exactly?
Well, Your Honor, I suppose what we have as far as genuine would be the testimony of Attorney Pattis. His motion, which is filed, and then I suppose we do know the physician's name. We could ask to have him, I guess, provide testimony.
Well, I don't have testimony from...
Or we could ask...
I don't have a testimony from Attorney Pattis.
Sorry, Your Honor.
I have a motion, and...
Yes.
So I don't have any... I have no evidence. I have argument in a motion is what I have. And then I have this letter that I have not seen, and you're asking for the first time the court to look at in camera. But, okay, so continue.
We've been answering questions sort of back and forth, Your Honor. When you say continue...
I know that you wanted to continue to argue and respond to some of issues that plaintiffs raised in their objection. So take your time.
Well, Your Honor, I know there's a claim here that this is both a threadbare attempt as well as... I'm not sure if it was a paltry attempt. There were both threadbare and flimsy attempts at delay. Certainly, I believe that opposing counsel is aware that Mr. Jones has appeared for numerous depositions in related cases, so he has submitted himself before. So I think that despite what the opponents might say is suspicious timing here, he does have a history of actually appearing for his depositions and providing testimony. So we think that's an unfair claim to make here. Again, he's willing to submit this to the court for its review. The procedures, I think, that have been suggested by the plaintiffs as being sufficient to seal and maintain confidentiality, our client believes, given what's happened in the Texas cases where such materials have been leaked and shared otherwise, I think he's just lacks faith in those procedures and thus has requested this procedure.
Attorney Smith, what is the objection of, at a minimum, providing to plaintiff's counsel or filing under seal a redacted letter? For example, removing the name of the medical condition and the name of the doctor. I'm not even sure is it the name of the medical condition that is the issue?
Your Honor, I think it's both of these concerns. I think it's both the name of his treating physician as well as what the medical conditions are. I think he's concerned about both of those things becoming public knowledge.
So at a minimum, you could exchange a copy of that letter, redacting the name of the doctor and redacting the name of the medical condition.
Again, Your Honor.
So that the plaintiffs have
At this point, I don't have authorization for that from the client. I can certainly discuss such a procedure with him to redact those things from him. I'm not sure if we redacted things that go towards the doctor's name as well as the various medical conditions, symptoms, etc., etc. I don't think that there's really much information that's left there.
Okay, so you're only authorized to request an in-camera review or nothing. So you're not authorized to even redact the letter. You want the plaintiffs to see nothing, even if it's redacted without the medical condition and the name.
That's correct, Your Honor.
All right. And so I'm going to get back to my original question. How do I determine this is genuine? I mean, it's just a name. I've got no address. I don't have a state. It doesn't have the name of any. How is the court supposed to, since you have the burden here, how is the court supposed to address whether it's genuine?
Well, Your Honor, again, I suppose we could have testimony, or if the court wishes, we can attempt to get affidavits, or other means of putting forward evidence to the court with regard to it. I understand that he is a licensed physician in Florida, and again, I can provide further information to the court. As I say, this is information that came to us yesterday in the afternoon, I think post 3:30 in the afternoon. I was in court this morning until roughly 11:30, so we go to the hearing with the evidence we have, not perhaps the evidence that we wish we had. And this is what I have at this point, though I am more than happy to endeavor to get other evidence for the court.
All right. Anything further before I hear from Attorney Matai?
No, Your Honor.
Do you know when you should know when your client last saw this physician, was last examined?
I believe he remains at home under his supervision, Your Honor.
No, I'm sorry. When he last was either examined by the physician or treated by the physician or consulted with the physician. When was the last occurrence?
I understand that was as recently as yesterday, based on this letter.
I guess I'm just trying to reconcile the information that's been provided to the court, which was essentially yesterday at 3:30. Mr. Jones contacted Attorney Pattis, indicating that he was with his doctor. I'm trying to reconcile that indication that he was with his doctor at 3:30 when he contacted Attorney Pattis along with plaintiff's opposition, which indicates that for 4 hours or so at the same time he was actually broadcasting live his show. So I'm just trying to figure out how it just doesn't make sense to me that he's with his doctor in the middle of a live broadcast. And you're telling me on the one hand, he's supposed to stay at home and he's restricted. But on the other hand, I have a formal citation to a broadcast, which suggests that he actually was working all day yesterday. So I'm just trying to reconcile this based on what you've submitted.
Yes, Your Honor. I guess two things. I'm not sure that that's anything more than the same argument that you have from us regarding the letter and as far as citations in their opposition. But moving aside from that, I believe that while he was working, to the extent that he was working, while he was broadcasting, if he was broadcasting, I believe that he was under the supervision of his physician.
So you're taking the court's time, right? And we did this on an emergency basis. And I'm not sure that I'm getting the information straight. But I don't see why there's any reason that any of this information should not be provided to the court. So to your knowledge, and if you don't know, we can take a recess and you can find out. To your knowledge, when did your client broadcast live yesterday, if at all? Do you know that information, or is that something you can find out because the suggestion was?
Your Honor, as far as I understand it, he was broadcasting at various points yesterday.
So was he broadcasting live after this purported recommendation from the doctor that he not attend his deposition? I'm just trying to figure out, is the only restriction basically you're not restricted physically. You're not restricted from driving. You can broadcast live, but you just can't attend the deposition?
Your Honor, that I'm not sure. I don't think that when the letter was sent to us that it sat to delineate exactly what all the restrictions might be.
So he's permitted to. There's no restriction on his broadcasting live from home, for example, based on your review of that letter.
Based on my review of that letter, I would say that so long as it doesn't exacerbate and doesn't conflict with what the results of the pending tests were.
So to answer the question, there's no restriction on his broadcasting live from home, but the doctor's restricting him or recommending a restriction on his deposition.
Yes, no restriction listed here noted regarding any broadcasting from home, but simply not to attend deposition this week.
Okay, so can you address that issue for me? How do I reconcile that? Why is it reasonable in any way, shape, or form for a doctor to only restrict a deposition, but not restrict any work or work-related activities? How does that make sense to you? You can broadcast live from home for 4 hours straight or throughout the day, but you can't sit for questions and answers under oath. Can you address that if you can?
I guess because when he goes, at least looking at this letter, when he would go to a deposition, I don't suppose he could remain at home under the supervision of the doctor.
Is the doctor at home with him?
I believe that the doctor has been with him, and he has remained under the doctor's supervision, Your Honor.
Physically with the doctor?
As I understand it, yes, Your Honor.
And what do you base that on?
I base that upon, again, without disclosing, I base that upon the information that I have here within the letter regarding the physician, as well as my knowledge of the client's whereabouts and who he has been in the company of.
Okay. So is there any reason then, if the physician is accompanying him during the broadcast and at his home, why can't the physician accompany him to the deposition? Wouldn't be the first time that happened.
That I don't know, Your Honor, but I don't suppose that would be remaining home, and we still have the pending test results. Again, these questions are probably not best put to me, but to the physician himself.
Put it
whose opinions these are.
But you haven't, Attorney Smith. You haven't offered you haven't offered the testimony of the physician. So I'm trying to get from you what little information that is available. So if the physician were to remain with him at home, he could be deposed?
I don't know, Your Honor. I would have to check with him to see.
All right. Anything further?
No, Your Honor.
All right. Thank you for being patient with the questions, Attorney Smith. Attorney Matai.
Thank you, Your Honor. Your Honor, this whole thing to me, and I'm choosing my words carefully here, is extraordinarily disturbing. Mr. Jones appears to be on the air right now, broadcasting his live show, The Alex Jones Show, as he does every day. I checked 10 to 15 minutes ago. He appeared to be on the air. I was just informed that among the articles he cited on the air was an article that you can tell from the broadcast was printed out today at 9:17 a.m. So while I sympathize to some extent with this position that Attorney Smith is in, not having been involved in this case before, what is clear is that this notion that Mr. Jones is responsibly complying with some unidentified physician's recommendation that he be at home under his physician's care is completely bogus. Dropped on the court and the plaintiffs less than 2 days before he's to be deposed for the first time in a case that's been pending since 2018. So although the plaintiffs do not have access to this letter, it seems obvious, both given the course of conduct in this case, the fact that there is no evidence before the court other than statements from counsel, and the representation I just made based on my personal knowledge of having looked at the InfoWars website. And I'd encourage Attorney Atkinson perhaps to pull it up on his computer while we're sitting here right now. That this is a dishonest attempt by Mr. Jones to avoid being put under oath, and perhaps to some extent to disrupt the plaintiff's preparation for his deposition, because we were forced to respond to this yesterday. We're on this hearing now. There's the prospect of testimony from this doctor, all while we're supposed to be preparing for his deposition. So in our view, there is simply no basis for the court to make specific findings that Mr. Jones has some medical issue that's going to prevent him from sitting for a deposition while he is currently on the air raising money for his legal defense. Yesterday, he was claiming during his broadcast that he's going to fight these lawsuits to the end. I invite him to do that by showing up at his deposition tomorrow.
All right. So Attorney Smith, have you lodged for appellate purposes, have you lodged the letters? You need to perfect your record here. Have you lodged the letter from the physician with the court?
No, Your Honor, we have not lodged the record with the court. We were waiting today's hearing.
All right. Well, I can't force you to do anything, but if you want to make this an appealable issue, doesn't it need to be submitted somehow? Are you intending to do that or not?
Your Honor,
I mean...
Again, we had authorization to disclose this to the court for an ex parte.
Right.
In which case we would submit it for such an in-camera review to the court as a court exhibit.
Well, couldn't it have been lodged and sealed? I don't just get it as an in-camera exhibit and then let it fly. It would have to be made part of the official court file for appellate purposes.
It would, Your Honor. It was unclear to us, I believe, whether or not the court would agree to an ex parte review, an in-camera review of it. If the court is inclined to do so, then yes, we will certainly lodge it with the court for that and ask that it be made a court's exhibit.
All right. So here's what we're going to do. You can lodge it with the court now by emailing it now to Attorney Ferrero, and he will be in charge of lodging it with the court sealed. And I am over objection going to conduct the in-camera review, but we now have a good appellate record. We will reconvene at 3 o'clock. So I want that emailed now so that I have time to read it. And when we come back at 3 o'clock, Attorney Smith, you will represent as an officer of the court whether or not Mr. Jones is currently on the air as Mr. Matai suggested. Do you understand?
Yes, I understand.
All right. So we will take a recess. I will await that document and we will reconvene at 3 p.m.
Several hours later.
All right. We're back on the record. I did review the letter. Thank you, Attorney Smith. You moved very quickly with that. And Mr. Ferrero, I'll direct you again to just make sure you lodge that with the court as sealed so that it is not accessible, but it is available for an appellate record. So, Attorney Smith, you were going to report back to the court as to whether Mr. Jones was broadcasting live before?
Yes, Your Honor. It appears to me that he is broadcasting.
Okay. And I did not ask you, but I am going to assume, based on what you've told me, that he is broadcasting live from his home. Is that correct, to your knowledge?
Your Honor, I'm not sure where he is broadcasting from exactly. I can't tell that from viewing the broadcast. I can see him on the live broadcast. And then Attorney Matai breaks in. Your Honor, I can tell, having watched Mr. Jones over many hours, that he is broadcasting from the studio that he always broadcasts from, which does not appear to be his home.
All right. So, okay. So because obviously part of the recommendation from this individual is that he remain at home. So we are going to pass it. All right. We're going to pass the matter for 5 minutes. Attorney Smith, you are going to come back and you are going to report to me whether that broadcast during our argument before we took this last break was from his home, which is what the indication is that he's confined to, or whether it's from his studio. All right. So we're going to take a 5-minute recess.
Your Honor, I will endeavor to do so. I'm not sure if I can get a hold of him in 5 minutes.
I have faith, Attorney Smith, that you can contact whoever you need to contact, whether that's Attorney Pattis or whoever else from the defendant has knowledge. It shouldn't even take you 5 minutes to find out whether that broadcast was from his home or from his studio. Because what's being presented to the court is argument that he is remaining at home and needs to remain at home and he can't leave his home. God help everyone if in fact that broadcast was from his studio in light of these arguments. All right, so we'll pass the matter.
5 minutes later.
All right, we're back on the record. Attorney Smith?
Yes, Your Honor, I reached out to get in touch with Mr. Jones as well as Attorney Pattis. I believe Attorney Pattis must be in the air because it goes immediately to voicemail. And I don't get a response to text, which is unusual for him. He usually responds to me. And the number that I called for Mr. Jones is not available, not taking calls right now. I don't have any way other than those two means to get in touch with Mr. Jones, so we called a number of times. I'm simply unable to get in touch with him in this short amount of time.
Are you troubled, Attorney Smith, by the suggestion from Attorney Matai that the live broadcast that was going on during your argument, where you were arguing that he was at home and that his physician was recommending that he stay at home? Are you troubled by Attorney Matai's representation that the broadcast appears to be from his studio and not his home?
Your Honor, I suppose I would be troubled by anyone not following their physician's advice, if that is what is the case here. Again, my argument is that what this letter submitted to us would indicate was that he was to remain home under his doctor's supervision. I have no way to enforce anybody following that. If they are not following that, I would be concerned. I'm also equally concerned by an invocation that God help everyone, depending upon what should happen here. Frankly, I think that turns the heat way up beyond what is necessary in this matter.
Attorney Smith, I would think that you would be as concerned as the court, as troubled by the court, given what information has been given to the court. So what we have is a letter that you have submitted that indicates that Mr. Jones remains at home. That is what the letter says, that he remains at home. Correct? He is, on my advice, he is remaining home under my supervision. So you have submitted for an in-camera ex parte review this letter that you're refusing to make available to the other side that says Mr. Jones is remaining home. Your argument is that he cannot attend the deposition because his doctor is recommending that he remain home, that he must remain home based on the doctor's recommendation. That is what you're telling the court in a nutshell. He must remain home based on the doctor's recommendation. And I have Attorney Matai representing to the court that he's broadcasting live from his studio during this argument that, in fact, he is not at home. This is very serious in the court's opinion. You're making representations to the court and submitting documents to the court that indicates he is remaining at home, but I have the lawyer on the other side saying he's not at home. That's his studio. What would you suggest that the court do with this situation?
I would suggest that the court perhaps have a hearing and have some testimony regarding these conflicting versions and withhold the decision. Or else, if the court is so inclined, then the court should rule on the motion for protective order.
And you're not at all troubled by the fact that you have submitted a letter from the court that indicates his remaining at home, and one of the other lawyers in this case has suggested to the court that in fact he is not at home? That's what the issue is here. The issue is, here, in a nutshell, that he can't attend these depositions. He's at home. He must remain at home. He is at home.
Your Honor, again, I've submitted to the court a letter from a physician treating him who says he is to remain at home under supervision that is dated as of yesterday. Again, I have not control over whether or not somebody is following that doctor's orders. I am not in Texas. I have tried to contact my client in order to confirm for the court where he is at this very moment.
Attorney Smith, I'm not faulting you personally in any way, shape, or form. You're just doing your job. But what you did was you submitted ex parte information to the court, which doesn't say recommend. It doesn't just say recommend. It says he is remaining at home. So I have you submitting this ex parte information so that the court is told he is remaining home. It's really not complicated. The court's told he is remaining home, and then I have Attorney Matai noting that there's a live broadcast during these arguments, and it appears, in fact, that he's at a studio and that he is not remaining home.
Understood, Your Honor. I'm trying to confirm where he is. I have never been to those studios. I cannot look at it and see and tell where he is. I am endeavoring to get that information to the court. I'm providing to the court all the information that I have.
I would think that you would have a duty and an obligation, given the evidence that you submitted to the court by way of this ex parte letter that indicates he is remaining at home, and by virtue of your arguments that he cannot attend the deposition because he is supposed to remain at home. If, in fact, the evidence that you submitted, the letter that says that he is remaining home, is inaccurate, wouldn't you have an obligation to correct that? That was what I was trying to give you an opportunity to do.
Your Honor,
because that is what you submitted, that he was remaining.
I would, but as I say, 5 minutes was insufficient for me to do so. I think it's insufficient for anybody to do so. I don't sit and watch InfoWars. Frankly, I don't watch InfoWars. I am here to represent my client. I am presenting the evidence that I have. I would say this letter is dated yesterday, is remaining home. I will seek to get something that is updated for the court. It appears, according to Mr. Matai's representations, which are being accepted not as simply argument, but as evidence, whereas, you know, we are not afforded the same, that here we are. I'm happy to get as much information as I can for the court, but again, the first news that I had that he was broadcasting live when Attorney Matai asked for us to turn on our television or computer or however somebody was looking at it.
Attorney Smith, I think the reason that I took the recess to give you an opportunity to respond so that you could actually represent to the court, and I was willing to take your word whether he was broadcasting from home or whether he was broadcasting from studio. I certainly did not. I reported what Attorney Matai said. Whether he's accurate or not, I don't know. I was giving you the opportunity to find out and to correct what the court has been led to believe.
Which I would love to do, Your Honor. However, as I said before, I do not think 5 minutes would be sufficient to do so. It did not prove sufficient to do so.
Attorney Sarang, did you want to be heard?
Well, Your Honor, I would just note that I did look at the live stream, the stream that's going on right now. I couldn't verify whether Mr. Jones was speaking in front of a green screen or not. Some of it's pre-recorded. It's plainly pre-recorded, and some of it I'm not, maybe or may not be. I can't tell. So that's all I have to say, Your Honor. Otherwise, you know, as an officer of the court, I make that representation. I have no other dog in this race.
Attorney Matai, anything else to add?
Your Honor, as we've been arguing here, we have been taking screenshots of Mr. Jones' live broadcast, and if it would be helpful to the court to make its own determination about whether Mr. Jones is in his studio that he is normally in, or his home, we can present those to the court. I am happy to make the representation that Mr. Jones is broadcasting from the same space that I always see him broadcasting from, and he often refers to it as being in studio. So you know, and then I would just, Your Honor, if you want further argument on the motion for protective order itself, I'm prepared to do that, but I don't know that that's what you're asking for at this point.
All right. So on the issue of whether the court has been misled or whether or not Mr. Jones is remaining at home, Attorney Smith, I have no doubt that you will take the necessary steps. And I mean this. I have no doubt you'll take the necessary steps to advise the court if, in fact, the court has been misled by your argument and by the statement in the letter that Mr. Jones is remaining at home. Okay? So I leave that to you for another day. If it does not need correction, then it doesn't need correction. But you'll look at the rules of professional conduct and you'll do, I'm sure, I have no doubt, you'll do what is appropriate and necessary in that regard. Okay, so now I'll get to the substance of the actual motion. So I would say that if the movants have submitted no credible evidence upon which the court can properly enter an order postponing the deposition of Mr. Jones, I have to say I have no idea as to whether the letter that I did review in camera is genuine, nor do I have any way of knowing whether the author of the letter is currently licensed. I have been called upon to review records for purposes similar to this for purposes of trial continuance or deposition continuances related to either a party or a lawyer countless times. But I have never seen one as bare bones as this one. This one did not have any letterhead. It had no address on it. It just has no indication of whether the doctor is the sole practitioner, whether he's in a group. It doesn't indicate what kind of doctor it is. There's absolutely no description of his practice. The court has no information besides a name. There's been no evidence besides that in-camera letter. The letter fails to address the length of the patient-physician relationship, does not say the physician examined Jones or evaluated Jones. Nothing else was submitted along the lines of a bill or doctor's note, any other evidence like that. And this is not actually a medical record. It is just this bare-bones note. With respect to the reasonableness of the recommendation that Jones not attend his deposition, the restriction really is that he is remaining at home and that he should not attend the deposition. The letter doesn't address any other restrictions that one would expect to see, such as limitations or restrictions on his physical activity or physical exertion, restrictions related to driving, restrictions related to work or work-related activities. And there is really absolutely no explanation at all as to why the recommendation that Mr. Jones remain at home. There's no basis for it, except saying, on my advice, he is remaining home under my supervision. And it appears to the court unreasonable to suggest that Jones can broadcast live 4 hours, whether it's from home remotely or from the studio, but he cannot sit for a deposition. And I say that because in connection with motions that were filed several years back in this matter, the court was called upon to review portions of Jones's broadcast. And I would say that at least the portions of the broadcast that the court was required to review in connection with the motions, the Jones demeanor during those broadcasts were anything but calm. So it is not... The court can't reconcile the nature of at least the broadcast the court saw, along with the deposition. It just doesn't make sense to the court that you can broadcast in such a manner, but you can't sit for a professional deposition with lawyers. And I again leave to counsel to address the issue of the letter from this purported physician, which states, quote, "On my advice, he is remaining home under my supervision." And counsel's arguments that he can't attend the deposition because he needs to stay at home, and the suggestion from opposing counsel that Mr. Jones is broadcasting from a studio, and what appears to be agreement by everyone involved that he has been broadcasting live today, including during the arguments that we've had. So, for these reasons, the motion for protective order is denied. Certainly, anyone can continue to file whatever motions they need to file on any of these issues, and I leave it to counsel to discuss themselves the logistics of the deposition along the lines of having the physician, assuming he is currently licensed, in proximity and available during the deposition on premises, so that should there be any issues, his physician would be available. All right. Anything else today?
Attorney Matei breaks in. Your Honor, I would just say since... And then Attorney Smith talks over him. Yes, Your Honor, with regard to the court's ordering me to advise the court whether or not the court has been misled, what form does the court wish that advisement to take? Should that be a letter to the court as well as to everybody, akin to something in federal court? I simply have never done such a thing.
Attorney Smith, when I say I have no doubt that you're going to do the right thing, I don't say that lightly. So I know that if anything needs to be corrected, I know you're going to do the right thing and correct it. My suggestion would be that it be done in the official file, because we have in this official file is the lodged document, and we also have as part of the record your argument. So if there needs to be a correction, and if in fact Mr. Jones is not at home and has not been at home, then I think it needs to be done in the official file. Okay? And if it doesn't need to be done, that's fine. Or even if you want to file a document that indicates that, in fact, he was home, just to clarify it, you can do that as well. Nothing stops you from doing that. Okay?
Okay. Attorney Matai breaks in. Your Honor, if I could just, for the record, and since Attorney Pattis is not here, if Mr. Jones wishes to be accompanied to the deposition tomorrow by his physician, the plaintiffs have no objection to that. And I did want to make clear that the deposition is scheduled to commence tomorrow at 9 a.m. Central Time at a location that Mr. Pattis has been advised here in Austin. And so if that could be communicated to him as well, thank you.
All right. Anything further?
No, Your Honor.
All right. We're adjourned.
All right, and that was the end of the hearing. But then, let's see, this is the March 23rd hearing. And what they've included is this section where the court says, I will say that in my opinion, I was deceived yesterday, not intentionally by Attorney Smith, and I made that clear yesterday, but I was deceived by the evidence and the argument Mr. Jones made about his need to not go to the deposition because he was remaining at home under court supervision. She meant doctor supervision. And I will say that only because Attorney Matai pointed out that that Mr. Jones was broadcasting live the day before the hearing and the day of the hearing, that was the only way it would have ever come to the court's attention, which is why I asked Attorney Smith for clarification. So I simply cannot accept argument of counsel without credible, genuine, and reasonable proof, and I don't have anything here. But I will say this, because there is no other evidence, proper evidence before me, and because I don't need briefing on the issue of whether he should appear for his deposition, I am going to order him to appear for his deposition tomorrow, ordered as part of the official court file, so that order will be in writing and it's on the record now. And that, of course, if there is evidence that's submitted that persuades the court that it would be dangerous to his health for him to attend the deposition, then that order may change. But right now, absent any amendment to that order, he is ordered to produce himself for the deposition tomorrow. Several things were filed on March 23rd. First, Attorney Smith filed something that I'm going to call a correct the record. He calls it a notice to the court in compliance with the court's March 22nd order. The undersigned submit this notice in compliance with the court's order directing them to clarify where Mr. Jones conducted a broadcast that occurred during a hearing that the court held on March 22nd from 2 p.m. to 3 p.m. Eastern Standard Time. After inquiring, the undersigned report to the court as follows. The broadcast took place from Mr. Jones' usual and customary studio in Austin, Texas. The studio is not located in Mr. Jones' home. Mr. Jones will provide the address of his studio to the court and the parties if requested, but he would respectfully request permission to do so under seal because his studio location has been the subject of harassment in the past, and that was submitted by Kevin Smith. The Alex Jones attorneys also renewed their motion for a protective order on March 23rd, this time including sworn statements from two medical professionals, Dr. Marble and Dr. Offit. They explained that Dr. Marble's personal observations of Mr. Jones so alarmed the doctor that he insisted on conducting a physical examination of Mr. Jones. He immediately advised Mr. Jones to go to the emergency room or call 911. Jones refused, and the physician advised him to stay home, which Mr. Jones did not do. The physician subsequently arranged for a comprehensive medical workup to be conducted on Mr. Jones on March 23rd. Mr. Jones was then seen by Dr. Amy Offit. Following an examination and testing, Dr. Offit has asked Mr. Jones to avoid too much stress until we have the results from his blood tests. Dr. Offit writes this letter, "This morning I had a medical visit, March 23rd, with Mr. Alex Jones for acute medical issues that were time-sensitive and potentially serious. We started a comprehensive medical evaluation, and he has labs that are pending to assess his redacted status. I have asked him to avoid too much stress until we have results from the blood test this morning. I also gave him ER precautions if he develops escalating symptoms. As a result of these findings, I'm advising him not to attend court proceedings for now." The problem I have with this is the failure to delineate between what's permitted and what's not permitted. He's not allowed to attend a deposition, but he's allowed to work. He's allowed to do his show. In most jurisdictions, if you are out of work or off of work for a medical issue, then you have other restrictions automatically in place. You might be able to stop at the pharmacy or your doctor's office or the lab for blood draws, or maybe pick up some groceries or some food, but then you're supposed to be at home, and you can get in trouble with either insurance or maybe other authorities or maybe some kind of work authority if you disobey these restrictions and then seek, the benefits of having to not work, and maybe you receive some kind of sick pay or something like that. Someone in there can get upset at you, legally speaking, for not observing those restrictions. So here is a letter, sort of incomplete letter. It doesn't really give a lot more information. Just says, I saw this person and they should not go to court proceedings. But it doesn't say not allowed to work, not allowed to do his broadcast, not allowed to research his however he does his research. And that seems on the edge, if not over the line, into quackery, into just a bogus letter to try and get him out of testifying. For what reason, I'm not entirely sure. It's not like he's never going to be allowed to testify. Is he going to have escalating symptoms forever in perpetuity and never be allowed to testify, but he's going to continue to do his show? I don't think that the court is going to allow that. Meanwhile, the plaintiffs have filed an emergency motion March 23rd for an order requiring him to appear at his deposition on penalty of civil contempt. Mr. Jones' deposition was noticed for today, March 23rd. The defense sought an emergency protective order to prevent the deposition, which was denied. The court's standing order is that a noticed deposition will go forward unless the protective order is granted. Mr. Jones did not appear for his deposition today, March 23rd. The plaintiffs have a right to take Mr. Jones' deposition. The court has the authority to order him to do so. Everyone's in place to do this, so there are attorneys both in Austin and in Connecticut ready to do their part in all of this. Basically, we're all waiting around, wasting time and client money if there's client money involved, and that the court has the ability to order him to the protective order and order him sanctioned or held in contempt. And the plaintiffs request that he be ordered to attend a new deposition date, March 24th, and to issue a capias or copias, basically to have him arrested. Now, this is not an arrest as a punishment for not attending the deposition, although certainly you could see it that way, but the legal reasoning for it is that you hold somebody so that they can attend the deposition, and you hold them until they attend the deposition. This is kind of similar to the Bradley Manning / Chelsea Manning situation, where Manning was accused of providing confidential information, I think it was to WikiLeaks, and then during the grand jury's investigation of Manning, Manning was held incarcerated in prison until Manning would testify about the relevant evidence and testimony required by the court. And then when the grand jury finally adjourned, there was no more need to compel Manning to testify, so Chelsea Manning was released, because it wasn't meant to be punishment. It was instead meant to compel Manning's compliance with the request. Same thing here. Jones could be held incarcerated or otherwise held by the court under arrest until he cures the defect of failing to attend his deposition. The plaintiffs also ask for an award of attorney's fees and costs. What the plaintiff is looking for is information about the Sandy Hook shooting and his hoax theory, any and all non-privileged documents and communications concerning information the deponent relied upon or referenced in connection with any on-air statement he made concerning Sandy Hook, the hoax theory, or the plaintiffs, transaction histories of fees and cryptocurrency investments, brokerages, etc. I think they're looking for information because remember, he's been held in default. He's got a default judgment coming. This is all to find what the damages should be. How much money did he make? How much money does he make? What can be considered damages in the defamation case? Records of exchanges of cryptocurrency into fiat currency are also included. So then the court issues a couple orders. Regarding the motion for a protective order preventing Jones from testifying, on March 23rd, Judge Bellis writes, Mr. Jones has by all accounts broadcast live from his studio on Monday and Tuesday in disregard of Dr. Marble's purported instructions to stay home and rest. Additionally, plaintiff's counsel alleges that even today Mr. Jones called into his show speaking on the war in Ukraine, although the court has no evidence to confirm that. While the court has no details regarding Dr. Offit's background or qualifications, it appears both from Dr. Marble's letter that the court reviewed yesterday in camera and from Dr. Offit's letter today that the medical issues, while potentially serious, are not currently serious enough to either require his hospitalization or convince him to stop engaging in his broadcasts. Mr. Jones cannot unilaterally decide to continue to engage in his broadcasts, but refuse to participate in his deposition. The motion for protective order is denied. Of course, if, as Dr. Offit indicates, he develops escalating symptoms such that he is hospitalized, that change in circumstance would excuse his attendance at a court-ordered deposition. The court expects that the deposition, which will be videotaped, will proceed in a calm, orderly, and professional manner, as all depositions should proceed. The court will be available during the deposition should any issues arise related to this order. And then regarding the motion for capias or an arrest, again, March 23rd, the court declines to issue a capias at this time, but notes that should Mr. Jones fail to appear for the deposition tomorrow, that he will be in direct contempt of the court's orders requiring him to appear for his deposition. Nothing prevents the plaintiffs from pursuing a motion for commission and subpoena, nor are the plaintiffs prevented from seeking sanctions should Mr. Jones continue to disregard the court's orders. The Jones defendants have requested an additional opportunity to be heard regarding the other sanctions that the plaintiffs have requested, and the court agrees that all parties should be given adequate time to brief the issues. As such, the plaintiffs should file a new motion regarding the deposition and sanctions if they so desire by 5 p.m. Friday, March 25th. The defendants should file an opposition by 10 a.m. March 29th, and the plaintiffs should file a reply by 10 a.m. March 30th. A hearing will be held on this issue March 30th at 2 p.m. Now, here's the part where we get some audience participation. Can you guess? Can you guess whether Mr. Jones showed up for his March 24th deposition? He did not. Notice that Alex Jones did not appear at his court-ordered deposition. That's a title of a docket entry that I haven't seen before. The plaintiffs hereby give notice that Alex Jones did not appear at his court-ordered deposition scheduled for today, and as a result, the deposition did not proceed. And that's followed by the March 25th motion for finding of civil contempt, which goes like this. Alex Jones is in contempt of this court. He is so afraid of being deposed in this case that he refused to attend his own deposition, even after the court ordered him to do so. His invented excuses for his absence only confirm his contempt. Twice, Mr. Jones sought emergency protective orders based on bogus argument that he was unable to attend his deposition due to health concerns. The court appropriately rejected those efforts, finding in part that the court had been deceived by the evidence and the argument Mr. Jones made concerning his health restrictions. By order of the court, Mr. Jones was required to appear for his deposition on March 23, 2022. He did not. By a subsequent order of the court and on pain of contempt, Mr. Jones was required to appear for his deposition on March 24th. He did not. It is impossible to overstate the level of contempt that Mr. Jones has shown for the court's authority throughout this litigation. It is also impossible to overstate the contempt he has shown for the plaintiffs. With dignity and courage, the plaintiffs subjected themselves to hours and hours of painful questioning by Mr. Jones' lawyers, and Mr. Jones plays sick when it is his turn to tell the truth under oath. He begs his audience to send him money to support his legal defense, and then ducks his deposition. It is absolutely no surprise that today, the day after he skipped his deposition, Mr. Jones was back on the air from his studio, explaining to his audience that the emergent medical condition that supposedly manifested just days before his deposition turned out to be a blockage in his sinus. Now that the blockage has cleared, he feels like a new person. It is no coincidence that Mr. Jones' sinus cleared as soon as plaintiff's counsel cleared Texas airspace. The plaintiffs now move the court to enter a finding of civil contempt and to issue orders to coerce Mr. Jones' attendance at deposition and to coerce that attendance immediately. More specifically, the plaintiffs move the court to order all of the following. 1. That Mr. Jones is adjudicated to be in contempt of court and that such contempt may be purged when Mr. Jones sits for deposition at the appropriate law offices and completes his deposition. 2. That Mr. Jones' profit motives for broadcasting lies about the plaintiffs and Sandy Hook shooting, his intent to harm the plaintiffs through those lies, and his culpable and malicious subjective intent are all established, and he is precluded from offering evidence to the contrary, and that these findings and preclusions will become permanent if Mr. Jones does not complete his deposition by April 15th, 2022. We would call this an adverse inference. If you refuse to testify in a way that you're allowed to be compelled to testify. For example, the Fifth Amendment, you don't have to testify about criminal things in a criminal case, but this is not a criminal case, and he cannot invoke the Fifth Amendment without consequences. By refusing to testify, the judge can infer that the things you refuse to testify about are adverse to you, and we call this an adverse inference. So they're asking for an adverse inference that Jones, has defaulted on all of these claims, and that the claims should be found against him. That Jones is to pay conditional fines beginning at $25,000 per day and escalating to $50,000 per day to the clerk of the Superior Court until he completes his deposition. That Mr. Jones is to be incarcerated until he sits for deposition. As I said, it would be to compel him to sit for the deposition, not to punish him for not attending the previous ones. The sort of punishment or compensation will come next. That Mr. Jones is to pay the plaintiff's fees and costs incurred in connection with the deposition that Mr. Jones failed to attend, including, but not limited to, time expended by plaintiff's counsel and staff in preparation, arrangement and travel to from the deposition, lodging, transportation, and deposition costs associated with the court reporter, videographer, and venue. And that the plaintiffs are entitled to such scheduling accommodations as their counsel may require due to the time wasted by Mr. Jones' willful refusal to attend his deposition, with the understanding that any such accommodations will not be reason for Mr. Jones to seek an extension of the trial date, and any other measures that the court deems appropriate to coerce Mr. Jones' attendance at his deposition or to remedy the prejudice to the plaintiffs. They do go over a conditional order of incarceration. In Connecticut, the court has the authority in civil contempt to impose on the contemner either incarceration or a fine or both. Sanctions for civil contempt may be imprisonment. The civil contempt has a lower standard than criminal contempt, so it's easier for the judge to find him in civil contempt and enforce those penalties than in criminal contempt. A trial court has the power to incarcerate contemners in civil contempt cases until they purge themselves, as I've said before. So yeah, that's very interesting situation that Mr. Jones has found himself in, putting the plaintiffs through hours and hours of their depositions, but then refusing to sit for even one. It was testified that this was his first deposition in the Sandy Hook lawsuit in Connecticut. So he's put the other party through the ringer as much as possible, but then he refuses to testify under oath. Probably because what he's going to say under oath is not going to be favorable to him. And if he refuses to testify in total, then by April 15th, the court could order those things, those claims that the plaintiffs have made, to be found as facts in his case, whether they're true or not, because Jones refuses to testify as to those facts under oath. This is the right way to pursue when someone doesn't want to sit for a court-ordered deposition. The way this works, the parties are supposed to do all of this without the court's assistance, and courts and judges usually hate to get this involved in discovery of evidence. When the court has to get involved with this kind of dispute, it's seen like it is a parent adjudicating a dispute between their children. And if it's clear that one of the children is wrong, in this case, the immature child being Alex Jones, then the parent or the judge will come down on them hard. And I expect that the judge will grant most, if not all, of the plaintiff's request for a finding of contempt and some kind of fine. I like the idea of a $25,000 fine. It has to be something that compels the contemner, in this case Jones, that compels them to attend the deposition or else suffer severe damage for not attending. I also like the idea of issuing an arrest warrant. Even if Connecticut can't get Texas to arrest Alex Jones, it's still a meaningful thing to put on the record. And all of this is setting it up that if he doesn't respond, if he doesn't attend his deposition, that the plaintiffs will win the entire case, everything that they want and need, because Jones has refused to participate in the deposition and adjudication of the matter. Again, Jones' attorneys put the plaintiffs through the ringer and had them testify for hours, but then he won't turn around and sit for his own under oath deposition. It's cowardly in my eyes. Let me know what you think in the comments below. And that's today's video. Special thanks to my top supporters in March: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Gutbrodj, Torpedan, ShadowTycho, Earthbound Star, PureMagma, TechTechPotato, Eric Tams, The Blood-Soaked Survivors, and Wyatt Calandro. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for our weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye.